Welcome to today's webinar, 5 Most Frequent HR Mistakes and How to Avoid Them, brought to you by the NFIB's Small Business Legal Center. To our current NFIB members, thank you so much for being an active participant in the small business conversation and for your continued support. To those who are not yet members, welcome, and consider joining the nearly 300,000 small business owners who are fighting for small business with NFIB. Our success is based on strength in numbers. Each new NFIB member makes our voice a little louder and strengthens our efforts to fight anti-small business legislation. If you are or know a small business owner, please visit NFIB.com or call 1-800-NFIB now. Before we begin, here are a few announcements. If you have any issues with audio, please ensure your computer speakers are set up properly and know that your internet connection does affect the clarity of sound. We are recording today's presentation, and after the webinar, all registrants will receive an email with a link to the recorded webinar and link to download the slides. We encourage you to enter questions in the Q&A box on the right of your screen. Just click Ask a Question and type your inquiry. We will address questions at the end of the program. And while we typically get many questions during these webinars, if we don't get to your particular question, we hope we will answer one that will be helpful to you. And I'll introduce our speaker for today. Our own Beth Melito is the Vice President of NFIB Small Business Legal Center. Beth has been with NFIB for 20 years, handling legal and regulatory affairs. During her time at NFIB, she has testified before Congress and state legislatures on a broad range of labor issues. Beth is an experienced litigator and educator, having previously worked at the U.S. Department of Veteran Affairs, representing hospital management and labor and employment matters in federal agencies and courts. And now I'll hand things over to Beth. Thank you so much.
Thank you so much, Casey, for the introduction, and thank you to everyone who is joining the webinar live or listening to the on-demand recorded version. Before we get started, and I apologize here, I didn't advance our slides here. If you are interested, if you are not an NFIB member and interested in learning more, you can click on the link there in the slide. I also want to flag that our webinar series continues the first Wednesday of every month at 12 p.m. Eastern Time. And next month, we are excited to welcome Felicia Watson, who is a senior counselor at the national employment law firm Littler Mendelson, and she will be providing tips on how to handle OSHA inspections and probably maybe even more importantly, how to avoid having an inspector knock on your door. Attendees will also receive a free copy of NFIB's Guide to OSHA Inspections. Our webinar series is the first Wednesday of every month, as I said, and I want to do a shout out to Casey and Scott Fegley, Casey Williams and Scott Fegley, who loyally join every month. Casey does the introduction, but coordinates the entire webinar series. And then Scott is our IT behind the scenes tech person. So Scott, thank you very much. Both Casey and Scott have been joining these webinars for years now, even before COVID. So I am very grateful for their support in our monthly webinar series. So jumping into today's topics here, we are going to cover the 5 most frequent HR mistakes. And I have provided this or given this webinar presentation over the years. I presented it to another association earlier this year, and I actually swapped out the 5th HR mistake and added in very quickly today. I'm going to touch on the Form I-9. So that will be the last HR mistake that I'm covering today because immigration issues are such a hot topic right now. And I know with small businesses, paperwork can be problematic, but the Form I-9 is one employment law form that you want to make sure that you have completed for all your employees. So getting into the 5 most frequent HR mistakes, let me quickly outline. Mistakes 1 through 4 are going to cover not being fair and consistent. Mistake 2, not being aware of what is going on in your workplace. Mistake number 3, not being engaged, not providing feedback to employees. Mistake number 4, not paying employees correctly. And as I mentioned, then I'm just going to quickly touch on the Form I-9. So 4 truths about employment law. And employment lawsuits can arise, let me go back here, from a wide range of legal disputes between employers and employees. And I should say employees, but it could also be contractors who consider themselves to be employees too. I'm going to touch briefly on worker misclassification when we get to the not paying employees correctly topic. So employment lawsuits can involve a variety of claims from wage and hour disputes to wrongful termination, workplace discrimination, retaliation, harassment. These cases can be brought under federal agency laws. So, for instance, the Equal Employment Opportunity Commission, that's the federal agency charged with enforcing the federal anti-discrimination laws, or under state employment law protection. So the State Department of Labor, and some states also have equal employment agencies. So employees have a variety of ways that they can complain about behavior in the workplace. So just be aware of that. They can file multiple claims and lawsuits. And as I said, the lawsuits can be brought under a variety of laws, and they can also be very expensive to defend. So the goal is to not have a lawsuit, not have a claim brought against you, because the bottom line is that the benefit of the doubt is going to go to the employee, whether it's a juror, whether it's a government investigator. More times than not, the benefit of the doubt is going to go to the employee, not the employer. So you don't want to be in a situation, you want to avoid situations where you have a claim brought against you or find yourself in court. And this probably should come as no surprise. What percentage of jurors would try to return a verdict for an employee who's unfairly treated, yet no law has been broken? And it's at least 68%. The bottom line, again, the benefit of the doubt is going to go to the employee, and juries will scrutinize employers' decisions. You don't want to end up before a jury. The average, I just looked up before I logged on today, because there is a law firm that keeps track of civil judgments against employers in the employment law context. The median judgment for an employment law claim is about $200,000. $250,000 actually if it's a jury award, and just over $100,000 if it's a judge trial. So you do not want to be going to trial on any sort of employment law claim. And the other thing is too, of course, that you would be paying an attorney in these instances probably to defend your business too. So, and the average settlement right now is about $40,000. Defense costs now going all the way up to pre-trial $125,000. Employment law cases and claims are very expensive to defend, and probably if you're like most NFIB members, you do not have any insurance that would cover employment law claims. Some of you might carry employment practices liability insurance, but a lot of smaller employers do not carry that sort of policy. So these sort of claims, defense costs, et cetera, would be paid out of pocket. So to avoid claims, what do you want to do? You want to make sure that you're treating similarly situated individuals the same. Doing that will reduce your legal risks. Make sure you have written policies, especially on no harassment. I'm going to touch on that in greater detail. And then finally, the open door policy on employee complaints. And when I say respond positively on the slide, I don't mean you are agreeing with the employees, but I mean that it is more of a thanks for coming to me. So you are at least welcoming complaints. Employees know that they can come to you if they feel that something is awry in the workplace. Again, you're not always agreeing with the employee. It's not necessarily going to mean that you need to take action on anything, but just that open door policy where employees feel they are heard. Mistake number one, not being fair and consistent. Establishing a pattern in the workplace is crucial. Haphazard discipline can lead to lower productivity, poor morale, and the potential for lawsuits. Again, the goal is to avoid any sort of legal claim, no legal claims. Employees who feel they have been treated unfairly are the ones who file discrimination claims. So how do you ensure fairness and consistency in the workplace? The best way to go about doing this is to have an employee handbook, this written resource. And it doesn't need to be a printed thing. It can be on online policy. And depending on the size of your business, I'm going to go through some not essential policies, but common policies that you find in employee handbooks. But it's going to vary depending on your business, the size of your business, the number of employees, the number of benefits you offer, that sort of thing. But a written policy really can be helpful in ensuring that everybody knows the rules of the road. It's a written resource, so you can have it in print, you can have it in digital, you can have it online. It formalizes policies for everyone in the workplace, employees, managers, the business owner. As I said, I'll run through some of the most common sections of employee handbooks. And we have NFIB's free model employee handbook too, for those that do not have a handbook yet and would like to. We have this available in Word version too online. So if you would like, take a look at that to get started on your handbook, or if you have a handbook and want to see, think there may be a policy you want to add. I think we do in our handbook, we did update our social media policy. So take a look at that. Again, the handbook formalizes policies so that employees have a resource, a written resource, again, whether online or printed, to go to and see what the rules are. So sections, essentials, or strongly suggested essentials there. There are no hard rules on what must be in an employee handbook, but these are some key areas, and I'm going to go through each of these in a bit more detail here. So the first one is that introduction to the company. This is the welcome statement and the company history. The handbook is a great opportunity to share your company's vision with everyone. NFIB has a nice historical statement. The history of NFIB, the founder, just a few paragraphs talking about, who the first owner, the core values of the company. All of this can set the tone for a better understanding of the policies. If you have real important, community involvement is very important, and things you've done with the community, those are all nice things that you can include in the company history. The code of conduct sets the foundation for healthy, safe, and respectful workplaces. And this is beyond expressing the sentiment of playing nice. The code of conduct, often this is where you can, if you haven't done so in the introduction to the company, the code of conduct is a good place to outline your company's mission, values, and culture. It might also address areas such as honesty, conflict of interest, compliance with the law, responsible use of technology, including social media. Again, we have a sample code of conduct in the NFIB Model Employee Handbook. So moving on to the employment policies, these can vary greatly depending on your company. And in this instance, less might be more. You don't want to, this is not where you put the blue sky plans for your company. This is where you want to put down policies that you are actually going to follow. So again, less can be more. You don't want to get too into the weeds, because probably then the policies are not going to be followed, especially if you are a smaller business that doesn't have a human resource department or an employee that handles just dedicated to human resource policies. Again, you might want to be go lighter on this section here. This is, however, where you do want to include the no harassment policy and the anti-discrimination policies. Again, no harassment, anti-discrimination, those are two must-have policies, and they should be in writing. Very important, because they will protect your company potentially from an employment discrimination claim there if they are in writing. And in fact, some state and local laws now require that employers maintain a handbook or a policy, written policy, to include such information there. So I think Colorado is one of the states where there are certain things that must be included in the employee handbook. So be aware, all this to say, be aware of any state law requirements regarding, you must, if the state law requires that you provide employees with a statement on no discrimination, no harassment, minimum pay standards, overtime standards, including them in your handbook can be a good way to go, because as you see there on the slide, the last thing that a handbook should have is a written acknowledgement. So that way you have covered yourself, not only good policy in the workplace, but you've also legally covered yourself as far as complying with a state or local law requirement. Other examples that you might include under the employment policies, in addition to the anti-harassment and non-discrimination, you should have an at-will statement unless you are a workplace that all your employees are in the collective bargaining unit, so in a union, but that's not many small businesses necessarily. So in that instance, you do want to have a prominent at-will work statement at the beginning of your handbook that reiterates that either you the business, or the employee can terminate the employment relationship at any time for any reason, as long as it is not a discriminatory reason. So that at-will statement can be very important. Again, anti-harassment, non-discrimination. You may want to outline under the employment policies employment classification. So if you have different categories of employees, you have exempt and non-exempt. Maybe you refer to them as administrative employees, but you may want to outline the employment classifications or different categories of employees, meal and rest periods, timekeeping, if you have policies on, punching in and out, work hours and expectations for punctuality also can go under the employment policies, in-person attendance, or if you have a hybrid policy. Again, make sure that you do not get too specific and don't lock yourself into a policy that at some point you might need to change, or always include the statement subject to change. But you may want to be, again, vaguer can be better when it comes to this. Good place to include under employment policies too, workplace safety and health requirements, maybe also a drug policy, drug-free workplace policy. Again, depending on your business, that might be a requirement of federal or state law. Cybersecurity and social media and privacy or other policies you might want to consider under the employment policies there. Then moving on to compensation and benefits. Benefits include all the non-monetary perks that a company offers employees, and this could include the leave policy too, or paid time off, depending on how. So you could have a separate category on benefits and compensation, or put it underneath the employment policy. So outlining components of the benefits. Again, you don't want to lock yourself maybe into anything too specific there, or you may want to, just reference a separate employees will receive, upon acceptance of employment will receive a letter outlining their compensation and benefits, particularly if you have different comp and benefits packages for different categories of employee there. And the last thing, and maybe most important thing, is that each employee should be required to sign and date an acknowledgement stating they've read, they understand, and they are going to comply with the handbook. Again, this can be virtual, it can be an online acceptance too. It doesn't have to be a hard copy there. But make sure you have employees acknowledge that they have been provided the opportunity to review the handbook, they understand it, and they will abide by the policies in it. So knowing what's going on in your business, as a manager, supervisor, or owner, you are charged legally with ensuring the safety and security of your workplace. And having policies in place that you monitor, you're aware of, you've educated the employees on the policies, you're aware of sort of what vendors are doing too, because this is also important that are coming in your workplace, even though they're not employees, they are interacting with your employees. So being aware of what is going on in your workplace, that's all part of ensuring that there is order and the employees are safe and are not subject to any inappropriate harassment or discriminatory behavior, anything like that. So workplace discrimination, it is forbidden by federal and state employment laws. The federal law, Title VII, and there's, a host of other federal laws that prohibit discrimination, the Age Discrimination Employment Act, the Americans with Disabilities Act, the Pregnancy Discrimination Act, and state employment laws too. So there's a lot of laws that prohibit workplace discrimination, and harassment is a form of discrimination, and it is a violation of the equal employment opportunity laws, both federal and state. And I already talked about how employees in many states have the option to file a federal complaint, a state complaint, and even in some municipalities, they can file an EEO complaint. So you want to make sure that you've protected yourself legally by having those no discrimination, no harassment, written policies, and your employees are aware of them, and that you are aware of what is going on in the workplace and the policies are being enforced. The policies do give you a defense against liability. The key is to have the written policy, to have shared it with employees, and then to make sure that you have a mechanism for employees to report any behavior that they believe is discriminatory. And again, discrimination includes harassment. Harassment is a form of discrimination. And I'm going to run through now. The policy here makes clear you're not going to tolerate any unwelcome sexual or discriminatory comments, followed to the letter. Again, making sure that supervisors, managers, and all employees are aware of the policy there, and spells out specific procedures for handling complaints. So one thing that is important with regards to this is in your policy, if you have a point of contact for who, discriminatory behavior or harassment should be reported to, it's always good, if possible. I know in smaller businesses, this isn't always possible, but ideally you have a second contact, because if the manager, who is the primary contact, is the individual who has allegedly engaged in the discriminatory behavior, you want to make sure that employees have somebody else, another individual that they can go to report that. I have there a screenshot from NFIB's Model Employee Handbook, the No Harassment, Non-Discrimination Policy, because our model policy answers those 4 questions on the left-hand side there. It talks about what is harassment, what conduct is prohibitive, what the potential penalties are. Usually it's, up to and including termination. And then most importantly, the complaint procedure for an employee to follow. So who do they go to with a complaint about harassment or discrimination? Avoiding the danger zones, offhand comments, sexual innuendo, email, and a one-off is usually not going to result in, a lawsuit or liability or anything like that. This is about making the workplace a safe place, a place that people want to come to, and making sure that individuals are comfortable there. So if you see something or an employee reports something that is offensive in some way, take action, stop it. It doesn't mean you're going to get sued, or it can be the basis of a complaint or anything like that. So this is not just all about avoiding legal liability. It's about making the workplace a place that individuals want to come to and spend. Most of us spend more time in our office or workplace than we do at home. Not some of us, some people do, not all of us, but some people do spend more time in the workplace than they do at home. So make it a place that people want to come to, because as I'll talk about in a little bit too, we want employees to stay. We don't want to be losing employees. We want to retain our good employees, and making sure that it's a workplace that is free from harassment, discrimination, is very important. So again, the legal steps that you need to follow, maintain that policy, written policy included in your employee handbook, investigate and stop any harassment situations, even if an employee has not complained. So maybe you witnessed something that you think, that's a little bit, odd. I really don't think he should be touching her, or she should be touching him like that, or take action. I mean, if it doesn't seem right, it probably is not. So take action, whether or not an employee complains, and then immediately stop any potential retaliation. Retaliatory claims are really one of the most common types of claims the Equal Employment Opportunity Commission receives. And how that happens is an employee lodges a complaint. Maybe there's merit to it, maybe there's not. But once they file that complaint, you want to make sure that a manager or supervisor doesn't take adverse action against the employee because they filed that initial complaint. And this holds true too for an employee who files a wage and hour complaint, who files a workers' compensation complaint, who takes FMLA leave. All of those could give rise to a retaliation complaint if the employee believes that the employer subsequently took adverse action against the employee because they exercised their legal rights, whether it was taking leave, filing a wage and hour complaint, filing a workers' comp complaint. So if you see potential harassment, hear of it, take action. If there are rumors, take action or investigate. Anyway, investigation is a form of taking action. And then take action to stop it. If you confirm that something has happened, take action to stop it and make sure that it does not happen again and that retaliation is not taken against any individuals who complained. Open door policy for complaints. Responding to the complaints, listen to the employee intently. Don't be multitasking when they come in your office and sit down and are sharing this. So you're not checking your phone, you're not responding to emails, filling out paperwork. Listen, remain neutral. Don't promise to take any action. Explain the next steps. You're going to investigate. If possible, it can be nice to have another manager in there who's not involved. So you don't want to bring somebody in if the employees, but it can be helpful then to have another third party witness in there, maybe who's taking notes if the employee is agreeable to that. Explain the next steps. You're going to investigate whatever the procedure is in your office. And then be prepared for these questions, because these can be hard questions. Can we keep this just between us? Well, that depends. So don't make any promises. You can explain that you're going to do the best to keep this confidential, but you can't make any promises. Again, legally, as an employer, you are required to take action to stop harassment, to stop discriminatory behavior. That's federal and state law. And if that behavior has happened, you can't necessarily keep it between us. You're going to need to, maybe share outside this meeting what happened and who you heard it from. You don't want to get anybody in trouble. Well, you're not going to get anybody in trouble. In fact, you coming to me has been a big help. And if a law was broken, i.e. harassment occurred, discrimination occurred, that person's action is what got them in trouble, not you coming to me. So, and reassure them again that, retaliation will not be tolerated. Nobody can take adverse action against them by bringing a complaint to you. Don't use my name. You can do your best and let them know you'll do your best to keep it confidential, but you cannot promise at the end of the day that you will not share their name. Can I tape record this meeting? This comes up more and more often with employees asking for permission before recording, and you can choose whether or not to allow them. You also, though, I want to say as an aside, you need to be prepared for employees not asking for permission and tape recording a meeting nonetheless. So all this to say that it's really, as a general rule, I think you should go into each meeting prepared for the possibility that employees may secretly be recording the meeting, and that the recording could be permitted as evidence in court or in a mediation or in some sort of government investigation, even if you've asked the employee not to record the conversation. Recording things in the workplace is also something that you can address in your employee handbook. And if you have any questions about that, feel free to drop me a note offline and I can send you some sample templates that you could include in your employee handbook about recording, videotaping in the workplace, because that can be a good way to address it too. And then if the employee even goes ahead, even if you have something in your handbook that says, recordings are not permitted without the consent of all individuals, if the employee does surreptitiously record a meeting, videotape a meeting, if you have a written statement in your handbook, that may be helpful in knocking the recording out as evidence in a sort of investigation, or if you were to end up in court for anything. So the best thing you can do is prevent employees making secret recordings is to promote an open and honest, supportive culture in your business. So that open door policy, letting staff know they can have a witness present if they like, that might be reassuring. No, we don't want you to record it, but is there somebody you would like to bring in the meeting? You might have a third party in there too anyway, so maybe it would be more reassuring to them if they can also have somebody who they trust in the meeting. That's another way to go about it too. And then just letting them know they can absolutely take notes. You'll be taking notes. They're welcome to take notes too. So all that maybe can shut down the videotaping of meetings or tape recording. Retaliation will not be tolerated. So that's very important. And that, again, statement to that effect should be in your handbook under the no discrimination, no harassment policies. Employee feedback. So this goes toward the recruitment, the retention of employees rather. employee feedback is so, so important because you want to make sure you are rewarding the high-performing employees, and you want to make sure that for employees who are struggling with performance, if you think it's possible to educate them, to coach them, to sort of rehabilitate them, if you will, and make them into a higher performer, you want to make sure that you are providing them with that opportunity to improve. So the performance improvement, working through that can be very important. So I have Zig Ziglar, probably one of the most well-known motivational speakers. He was a salesman, so I'm fond of his books and teachings because NFIB is so reliant on door-to-door sales individuals, our sales force there. And I love this quote from Zig that people often say that motivation doesn't last. Well, neither does bathing. That's why we recommend it daily. So positive feedback on an ongoing basis is just so important. And it makes employees feel that they are valued, they're part of the team, you depend on them, and they're doing a good job. You know they're doing a good job too, letting them know that you know they're doing a good job. Engaging employees to stay. This will go so far towards that retention of your high performers. And it's, I did a webinar last month for another association on recruitment and retention. And in preparing for it too, I went through a lot of different studies from different HR firms, and it's just amazing how when you survey employees, pay is important, and rewarding employees with a bonus, but it doesn't even have to be a big bonus or a bump in pay, an annual bump in pay if they're performing high, but it doesn't need to be a lot because employees leave employers, leave businesses, leave companies, not because of the pay, but because of other things. They're not getting feedback. They're not being assigned new tasks. They're not being trained up. There's no promotion potential. Pay is really only about 50% of the reason that most employees leave. It's all those other things that cause employees to walk out the door. So not evaluating all year long. Again, performance feedback should be given on an ongoing basis, positive and negative, documenting performance throughout the year. So if an employee, let's say, does a great job with a particular project or task, you want to let them know that you acknowledge that, share with them that, they did a great job, maybe in a staff meeting, let everybody know that, Sally did a great job on this report. It was fantastic. And then also noting that down. So maybe you have a file or an email folder for Sally, and just making a note of that too. So then when you do the written annual performance review, you have these things already. It makes writing the performance review so much easier if you're sort of keeping this list of, all the great things that Sally did during the year. And if there's anything that maybe an area that she maybe could improve on, maybe it's, attendance. She just can't seem to get into work on time, noting that too, and maybe the times that you've talked to her about that too. So that can all help sort of the documenting the performance throughout the year. It makes writing the annual performance review much, much easier. Just some tips for writing the annual evaluation, and then corrective action. I'm going to spend a little bit more time on that. I already talked about praising in public, criticizing in private, and having a meeting with employees on, performance issues is very important. Again, not the annual review too, but when things arise, going back to the attendance issue, you have an employee that just cannot get to work on time. How are you going to address this? Well, you're going to start by having a meeting with them rather than just offhand saying, Tom, again, you're late, 10 minutes, 9 o'clock, 9:10. We've talked about this. Sit down with Tom. What is going on? Like, is there anything you can do? Well, Tom tells you that he is responsible for waiting for the bus, and the bus is late. The bus is supposed to come at 8:30. The bus has not been getting there till 8:40, 8:45. He has a 5-year-old. He can't leave the 5-year-old at the bus stop. Having a conversation, is there any way then that maybe you can adjust Tom's work time to 9:15 or 9:30 so that you're not irritated and Tom's not stressed out because he can't leave the 5-year-old at the bus stop. So things like that, having a conversation with the employee, like, what is going on here? What is there anything I can do as the employer to address the situation to make it so that the employee is meeting the expectations? Does the employee not understand how to close out? So they're missing a step and closing out the store every day, but they weren't even aware of a step because there was no written sort of checklist of that they had to go through every night. So things like that. Again, having the meeting with the employee can be a very important first step. Establish deadlines for improvement. So a follow-up meeting can be good there. Giving the employee to explain their side of the situation. Again, at the end of the day, it's about helping the employee perform. It's generally, unless it's misconduct or somebody who you've been working with, or there's just, poor attitude, in most instances, helping an employee become a higher performer is going to be the better course of action. It's going to be less expensive. It's hard to find employees. So firing employees is expensive because then you are short. You've got to, rehire somebody else. You have to retrain somebody else. And during that period of time, you're down an employee there. So give the employee the opportunity to improve their performance. Help them do that. Then, unfortunately, there are going to be situations where exits are unavoidable. Having a procedure, again, a policy, a checklist. I'm a big fan of checklists there because that can be very helpful too. You may want to involve outside counsel, particularly if you are doing a severance agreement with the employee. Always good to have an attorney review the severance agreement before you show it to the employee, share it with the employee. Make sure you're aware of last paycheck laws, what is required in your state. Does it have to be, if it's some states, if you terminate for misconduct, you have to provide the paycheck at the time of termination. If it's a layoff, then maybe you can provide the paycheck the next pay period, or if the employee quits the next pay period. What is the requirement of your state? Be very careful about deducting anything, unreturned equipment, unreturned uniforms from the last paycheck, because most state laws prohibit deductions from the last paycheck other than, the standard taxes, insurance, that sort of thing. ERISA, did you give the notice if there's health insurance involved? All those sort of things. Having that checklist can make sure that you have all the bases covered with the termination. Okay, moving on to the wage and hour issues. This is a big area for litigation. And it's really costly too, because unlike employment discrimination claims, there is no intent required for wage and hour claims. Wage and hour claims are strict liability. So you are liable if you have paid an employee wrong. In other words, you didn't pay overtime, you misclassified an employee, an independent contractor, and they should have been an employee. You have somebody misclassified as exempt and they're non-exempt. So again, they're entitled to overtime. These are all, again, it's strict liability. So if you're wrong, if you've been mistaken, or if the state or federal wage and hour department thinks you're mistaken, you are liable. And then of course, hiring the attorney can be expensive if you're going to defend yourself in a claim too. And you could be looking at back pay up to 3 years. So again, you want to make sure that you have done a wage and hour audit. DOL estimates that 70% of employers are out of compliance with wage and hour laws, and I suspect it may even be higher than that. It's really hard, depending on the number of employees you have, to be 100% in compliance all the time with wage and hour laws, because the laws are tricky, they're not intuitive, and you have federal, state, and sometimes even local wage and hour laws that you have to comply with. It's very difficult. So I mentioned already the most common wage and hour mistakes relate to misclassification. So you have an employee who you've classified as exempt, and really they should be non-exempt. They should be an hourly employee, so they should be entitled to overtime. And then the other most common one is the misclassification of a worker as an independent contractor when in fact they should be an employee. And then the problem there is you've been paying them as a 1099, you have no payroll records. So what happens? This worker comes in and says, I should have been an employee. I've been doing work for this company for 3+ years. And that entire time I was working on average 50 hours a week. Well, guess what? You have no payroll records because they were not an employee. And who is going to win that overtime claim? Probably the worker, because again, benefit of the doubt goes to the worker. Another area of concern or claims is off the clock activities. So meal and rest periods that are unpaid, but they really should be paid because they're not, the individual is sitting at their desk, still responding to emails, still answering the phone, or their meal break is only 15-20 minutes, or they're doing preliminary or post-preliminary activities. So they are having to stop at the bank to do a deposit on their way home. They are having to log on at night and they're an hourly employee, but they have to log on their computer at night to submit some reports. Travel time too is a very tricky area. All of these are covered in the NFIB wage and hour guide. And I think I have a screenshot of that guide. Again, that guide is available free on our website, and it goes through all of these bullets here in more detail. Let me move on to most common exemptions here. The white collar exemptions are the executive, administrative, and professional exemption there. To be exempt, you must be paid on a salary basis, and you must receive at least $35,568 per year, which comes out to $684 a week. And you must receive, with a few exceptions, the same set salary every work week. And it's based on work week too. So every work week, you must receive the same set salary. Employees who are not exempt don't fall under one of those exemptions too. Oh, I also want to touch on too, that equity owner, because we might have some business owners on this call. Another exemption from the overtime pay requirement is if you have a 20% equity interest in a business. And the highly compensated employee exemption, employees who are paid $151,164 per year, would fall under the highly compensated. The other exemptions there, outside sales, computer professional, are discussed in more detail in the NFIB wage and hour guide. So bottom line, you want to make sure if you have somebody classified as exempt, they are being paid that minimum salary amount, $35,568 per year for the white collar. They are being paid on a salary basis, meaning they are being paid the same amount every work week. And then the third thing is you want to make sure they are performing executive, administrative, or professional duties. And those duties are outlined in the wage and hour handbook. You can't just call somebody an administrative assistant and pay them the salary and assume that they are exempt, because if they don't have, as defined by the U.S. Department of Labor, administrative duties, they could be entitled to overtime. It's not based on the title of the job. It's based on the actual duties, the performance in the job. Things that are not regulated under federal law, and this surprises individuals, is that there's no federal vacation pay, holiday pay. Many employers offer this. We've got the 4th of July this week, and I know many businesses offer time and a half or even double time to entice employees to work shifts on the 4th or other holidays, but it's not a federal requirement. Some state laws do require rest breaks and meal breaks, and those are outlined on the U.S. Department of Labor's website. They have a map that you can click on if you are unsure of your state meal or rest break requirements. Not all states have such requirements, but many do. Calculating overtime, there's 4 steps. Determine the work week. Overtime is calculated on a 7-day work week. It is not, you can't lump together 2 weeks. It's per week. Determine the hours worked, their regular rate of pay, and the overtime then is 1.5 times their hourly rate. Beware of off-the-clock activities. I mentioned the situation where you have an hourly employee who is having to log on at home at night to send reports or emails. That would be time worked and should be included in any overtime calculations. And oftentimes these sort of activities are not included in time worked, and they can lead to overtime claims. So be aware of that. Training time too, and I mentioned already that travel time can be a little bit tricky depending on whether the travel is after hours and whether the employee is driving or a passenger in a car. It's very complicated. It's not intuitive, but again, all outlined in our wage and hour handbook. So if you have hourly employees, non-exempt employees, you really want to make sure you are aware of when employees are engaging in off-the-clock activities, and you really want to make sure you are clear on the travel time rules. Okay, before I move on to the next topic, I just want to say be proactive. So if you have a lot of different job classifications, particularly those white-collar jobs, the administrative and executive employees classified as those two categories, take a look at the duties test for those two jobs, because you want to make sure that it's not just based on the title and it's not based on an old position description that includes things that employee is no longer doing. So you want to make sure that you are meeting, again, all the requirements for exempt employees: salary level, salary basis, and duties. Okay, moving on to the last mistake here. And this is very timely because of the focus from the administration, from the Department of Homeland Security, on ensuring that employers are in compliance with the federal immigration laws. And you want to make sure that you have a Form I-9, which is the federal form, and I think I do. I have a screenshot of it here, for all your employees. So even if it is your son or daughter, or your mother. I got that question a couple of weeks ago. Well, this is my mom, but she's an employee. Yes, she gets a W-2. Yes, you do need to fill out a Form I-9 just in case. You just don't want to have any gaps there. So the Form I-9, if you have not filled these out for your employees, you want to do so. Ensure they fill out section 1 of the form when they start work. Properly complete. You, the employer, fill out section 2 of the Form I-9. Retain it for 3 years after the person begins work, or 1 year after the person's employment is terminated, whichever is longer there. And then make sure all your Form I-9s are kept together. They should not be kept in individual personnel folders. You want to keep all your Form I-9s together. And locked too, of course, like all your personnel folders too, they should be locked. If you have a Form I-9, if you do a Form I-9 audit, and this can be a good practice, particularly if you haven't, done one, not sure that the previous owner of the business filled out Form I-9s, and you still have a lot of the employees that have been around for, 10, 15 years. Now would be a good time to have somebody, whether it's you or the HR person or the office manager, complete a Form I-9 audit. And we do have more information on our website how to go about doing that. The bottom line is, if you find incorrect information, have the employee fill out a new form, or if you determine that you don't have a Form I-9 for employee, have the employee fill out a Form I-9. And date it. Don't backdate it to the date they started. You want to date it the date they fill it out too. That's very important too. Store all I-9s together, not in individual personnel folders. We hosted a webinar in May, just 2 months ago, rather, or was it it was in June, with Laura Reif, a partner with Greenberg Traurig. She provided, in addition to talking about Form I-9s and doing an audit, she also provided more information, general information too, on immigration, sort of the lay of the land right now, visa, E-Verify, if some of you engage or are interested in E-Verify too. So that could be a very informative webinar. Take a look at that. That's on demand that we have available. And I think we still have some time for some questions here. I'm going to stop sharing my screen now. Here we go. I don't know if we have any, if we have any questions here. Let's see.
Are you on camera? Are you on camera, Beth?
I am on camera now. Thanks. So we have just a couple questions here. Can I can an employer make an administrative assistant exempt but still pay overtime because they don't fall in any of the categories of the duties or the duties don't meet the requirements? You can pay overtime to exempt employees. I think the safer course of action, and you can, here's what I'll say, is you can have hourly non-exempt employees paid on a salary basis. So that might be the better way for me to put it. You can have non-exempt employees paid on a salary basis. So that way they are insured of basically the same amount every week, but they are also entitled to overtime then. So that is something that you can do absolutely, because in this situation, the employee that Marty has is not entitled to the exempt classification, because even though the individual's title is administrative assistant, they are not fulfilling administrative duties as defined by the U.S. Department of Labor. So the individual can be paid on a salary basis, but they would be entitled to overtime. How long do we retain employee files? That is a great question. Believe it or not, NFIB has a document retention guide too. And it varies somewhat from state to state. So some state laws actually now have requirements on how long employers must retain. A good rule of thumb generally is 3 to 5 years after the employee has left employment. So I would say minimum of 3, but I know some employment attorneys will say 5 years is the better course of action after the employee has left. Why not have I-9 in the employee's files? Because if an investigator comes in, you need to have them all together in one place. So you want to have them all in one folder. You don't want to be pulling them out of individual employee files there. You only want to be showing them the Form I-9s. And hopefully this never happens. I hope none of you have a Homeland Security person coming in doing a Form I-9 audit there. But if it does happen, you want to have them all in one folder there. And that also makes it easier too than to do if you're going to perform a Form I-9 audit. So that is why. Somebody is asking for the template regarding recording in the workplace. Absolutely, that's Cheryl. And if I'm going to, I don't know if my email address was on any of the slides there, but I'm going to drop that in the chat box there right now so that people will have my email, because you can email me directly, Cheryl, for that. Any of the other templates I mentioned too, or guidebooks, if you can't find them on our website, feel free to reach out to me directly. As I said, I'm going to put my email address, and if there's any other questions too that you would like to ask that you're not comfortable asking online, reach out to me. We are happy to answer questions. NFIB does have, the Legal Center runs a support line, and to get in touch with us, our support line, it's info@nfib.org. We respond to inquiries usually within the next business day. You can also reach out to us at 800 NFIB now and ask for the Legal Center there. We are happy to provide general information on HR and employment law matters. So that is another resource there. And it looks like that might be all we have here, Casey. Let's see, let me go back. Oh, we've got some, I'm sorry, we've got some more now. Do you have to have the I-9s printed, or is it okay to have them scanned digitally? Melissa, great question. It's okay to have them scanned digitally. Good question. Do I need copies of the social, lots of questions about the Form I-9, and that's great. Do I need copies of the Social Security cards and licenses with my Form I-9s? Whether or not you make copies of the whatever document, government document the employee shows to prove their identity, to show who they are, the most important thing is consistency. So you want to make sure if you are making copies of the license, the Social Security card, or the passport, depending on which documents the employee shows you, you want to make sure you're doing it for everyone. So you're not selectively doing it. Like, I'm just going to do it for the men, but not the women. You want to make sure that whatever your practice is, it's the same practice for all your employees. Laura Reif, during the webinar, did recommend keeping copies. And she did recommend, of course, consistency with all the employees. So she did recommend keeping copies of the Social Security cards and licenses. But again, it's not a requirement. So that's a great question, Erin. When termination of an hourly wage employee is imminent, what initial steps do you need to be aware of to avoid complications? So I would say the most important thing is if they are being terminated for misconduct. And when I say misconduct, if it's a reason that you think might disqualify them for unemployment, this is a question we get a lot on our support line is their termination is imminent and the employer is looking to document things because they are thinking it might disqualify the individual for unemployment. Again, you want to make sure you've got the documentation there. I would say the other thing is to not prolong the process or the termination. So hire slowly, fire fast is something I've heard many HR professionals say there. So hire slowly, fire fast. So to the extent possible, do not prolong the, drag out doing the termination there. And then make sure, again, you've checked to make sure, what are the rules, your state rules on the last paycheck. If you're in a state where you need to provide, and some states require this, the paycheck upon termination, have it ready, have it there ready. Make sure you are aware of state laws on paying out vacation. This comes up a lot too. And this is something that if you get it wrong, will send an employee off to file a wage and hour claim or off to an attorney. So avoid it all. Just know what the rule is. And when in doubt, just pay it out, really. If they've got 5 days vacation, is it worth quibbling over that if it's going to send them to an employment attorney? Probably not. Just, when in doubt, pay it out. Don't deduct from that last paycheck either for the uniform or whatever. I would say set up a meeting, have a witness in there when you carry out the termination, have your checklist, get the keys back, any other equipment, get it back there. And another good practice too is to not necessarily hide the ball. So if they're being terminated for performance reasons, you can even, have a script there. We've met before, you were aware that it has not worked out, improvement was not shown. Don't hide the ball. I mean, they're probably aware of why they're being terminated. They might proclaim shock and all, but just kind of mapping it out, what you're going to say, your script, your checklist, getting it all in order, your ducks in a row, and handling it sooner rather than later is a good thing. Let's see if there's any more came in. We've got one. If your employees are at last one here, then I think if our employees are at will, why worry about documentation of problems? Why not? Thanks for your time, but we will no longer see you. Great question there. So that's a great question. You can do it that way. There's nothing that legally requires that you put employees on a PIP, that you give them a written warning. That's oftentimes misunderstood by both employers and employees. If it's employment at will, either party can quit the relationship at any time for any reason. On the employer side, you just can't do it for a discriminatory reason, i.e. you can't fire Beth because she is female, or Will because he's over 40 and you don't want to employ anybody over 40 because the health insurance is expensive, anything like that. So you can do it without a reason, and some employers do that. But I do think at the end of the day, when the employee sees that you've got documentation, and again, you don't need to belabor it. It can be scripted out. Just remember we met, this didn't improve, and in fact, it got worse. And as a result, we are letting you go effective today. So it doesn't need to be anything long drawn out. But I think showing that you have documented, you've taken it seriously, will go a long way towards protecting yourself from a claim, because when the employee sees that, I think they're going to be less apt to go off and try to file anything. Again, especially if you have everything in order, you will be receiving your check on this date. Here's the paperwork for your health insurance, just all this being very professional. Again, there's some situations where you're going to need to just let them go and send them on their way. I get that. Okay, Casey.
Thanks, Beth.
Yeah.
All good?
Yeah,
All right.
all
Thank you,
good
everyone.
here. We've got one
you
more
for-
here on tips. I'm sorry to
Okay.
interrupt. One more
Mhm.
here. Let's see, on tips, but I think if that individual can reach out to me directly, that would be great because it's a bit more complicated, but I'm happy to answer that. Thanks. That's it, Stacey. Thank you,
Okay.
everyone.
Thank you. Visit nfib.com/webinars for all of our webinars on demand. I'm Casey for NFIB. See you soon.